Hello, good evening, everyone. Thanks for joining us today. We're going to go ahead and get started. I know more folks might be joining, but just because we've got a lot of conversation before us, we're going to jump on in. My name is Jenny Mattingley. I'm the Vice President for Government Affairs at the Partnership for Public Service. For those of you who aren't familiar with the partnership, it's a nonpartisan nonprofit working to build a better government and stronger democracy. We do this through policy ideas to make the government work better, helping federal employees in the leadership development space, workforce programming, and of course, convening conversations like this one to help support the federal workforce. We know many of you are here because you have a lot of questions about the executive actions that have taken action over the last few weeks and how they impact you, your families, and your colleagues, and also how they impact the mission of your agencies and the work that you do day in and day out. So we know too that there's a lot of confusion and anxiety out there, especially since so much of this is happening so quickly and without a lot of time to work through it. And we also know finally that those of you listening in who work in the government really care about public service and are worried not just about how these actions will impact you and the people you work with, but also how they'll impact the people across the country and around the world who rely on and interact with our federal agencies and programs. We're here to help support you as best we can through resource sharing. We've got a website, I'll mention it again, with FAQs. We're also providing plain language explainers and webinars like this one, and really continuing to do what's a hallmark of the partnership, which is sharing the stories of the incredible work that federal employees do for the country. So before we kick off, I just want to thank you all for your service and for the work that you do for our country. With that, I'm going to jump into a few housekeeping notes, and then we'll dig into today's content, talking about some of the rights that federal employees have, how these different processes work, and hearing from our two guests on those. But before we kick off, a disclaimer: the information that we're providing in this session is for informational purposes only. It's general information. It provides an overview of the typical processes and various employee actions. It's not intended to provide legal guidance. If you require legal advice, we recommend consulting with a qualified attorney who can assess your unique circumstances. With that being said, we're going to do our best to dig through and analyze these issues. And we're also doing it in real time a little bit since things are moving quickly, and some of the things leave more questions than answers at this point. But we've got some great guests on who are going to provide their understanding and experience with federal employment rights as they stand under current rules and laws, and generally how employees navigate them. And throughout OneNote, we've got a Q&A function. You can submit questions anonymously, and we'll work to get through those as well. But we are not going to be able to answer every question tonight because there are a lot of you on, and we only have so much time. So we'll do our best to get through those. We have other webinars coming up that might cover those topics, and we will also be posting these recordings on our Resource Hub website as well. One last thing, while this discussion is geared towards current federal employees, it's an open forum, so we may have folks joining us from other outside communities, good government, media, private sector, and we welcome you here, but just wanted to flag that most of these issues that we're talking tonight are very specific to the federal employee community. And if your question isn't answered tonight, or you have more specific individual circumstances, again, reach out to your HR offices, seek legal guidance from your agencies or an outside attorney, and just continue to support each other. And before we go on, some quick introductions. Again, I've got two colleagues here joining me from the federal community, and would love to have you both just give a very quick introduction. And Art, I'll start with you.
Great. Good evening, everybody. I'm Art Gary. I retired from the federal government in 2023 after 38 years of federal service, all of which was as an attorney in the general law area, which is the management of federal agencies generally. And of course, a large part of that, a substantial part of that was personnel law. And I've both as an attorney and as a manager, I was at SES for 20 years, and the last 11 of which were at DOJ. I have overseen and managed and participated in all aspects of employment law, and I hope I haven't forgotten more than I have remembered, than I'm remembering now that I'm a year and a half out in the retirement, but happy to be here.
Great, thanks for joining us. Bob, over to you.
Great, good evening, everyone. My name is Bob Erbe. I'm an attorney in private practice, practicing exclusively federal employment litigation. I represent employees and unions before the Merit Systems Protection Board, the Office of Special Counsel, the Federal Labor Relations Authority, and arbitration. Prior to that, I was an agency attorney for 20 years. I did exclusively labor employment law for the Department of Air Force, the Bureau of Gravity and Printing, Immigration Naturalization Service, Customs and Border Protection, and Immigration and Customs Enforcement. So I've handled over, I would say, 200 MSPB appeals, litigation before EOC as well. And also I'm retired Air Force in the military as a JAG, and I just retired in July of 2024.
All right, thank you. Really appreciate you both bringing your years of experience here tonight, because I know, as I said earlier at the front, there's a lot of questions that we've been hearing from folks, which is why we're having this conversation, to sort of help people at least generally navigate or ask questions. Before we jump in, one last thing, my colleague Jackson is online, and he's going to be tracking the questions that we're getting from folks. And so people listening in may see Jackson come on screen from time to time, and that's usually our cue that there are some questions coming in that we're going to stop and deal with. So, and one other thing, there's an update, just, I know this kind of goes into the topics, Art, Bob, that we're going to be talking about, but for folks who haven't seen the news, a lot of the questions that we've been hearing are around the deadline tonight for deferred resignations. And we just saw that there was a lawsuit out there that just put a cease activity order related to that deferred resignation offer, also called the Fork Directive. And so it's in response to a lawsuit filed against the Office of Personnel Management. And so in practice, what that means is that I take it to mean feds do not have to make a decision tonight on accepting that deferred resignation. And so I think the new deadline right now announced by OPM is February 10th, right around midnight. So at any rate, there's more to come. And this sort of goes into that whole question of legal process and what feds might be seeing. So I'd love to kick off there with both of you to talk a little bit about due process rights and adverse actions and the things that people may be familiar with and how that plays out kind of in this current environment. So what are those things, and give us a little background. And Art, do you want to jump in first?
Great. So can you see me, correct, and hear me?
I do. Yep.
Okay, great. So an adverse action, I think almost everyone is familiar with what an adverse action is, but basically it's a suspension. There are divisions in terms of the process that goes with each kind, whether it's 14 days or less or 14 days or more. It's a reduction in grade, a reduction in pay, removal, a furlough for 30 days or less. Basically there are a lot of actions that are employment actions that are not adverse actions. And as we're going to talk about, each one has its own kind of process. Depending on what the action was taken or the way in which it was taken, such as a discriminatory action or something, there are different forums and different ways to seek redress of adverse actions.
That's great. And Bob, one of the things Art just said, and I think we all spoke about this beforehand, is how many both different forums, but different forums apply to different employees based on what are they a senior executive? Are they bargaining unit? Are they, everything is different. So it's hard sometimes to do this general overview.
Correct, because everything, depending on your status as a federal employee, that depends on your rights. So the Civil Service Reform Act of 1978 was created. So we have all these different adjudicatory bodies: the Merit Systems Protection Board, the Office of Special Counsel, the Federal Labor Relations Authority, and then also the EOC. So depending upon the action taken and the employee's protections or rights, they might be able to go to one of those different forums. So all those forums are out there to protect federal employees on various employment-based actions. So the complicated thing is that you have to know which exactly forum you can go to. And the other, which we'll probably talk about later, is the law is set up that generally you're not allowed to do a shotgun approach. So if I'm affected by an employment action, I can file an EOC claim and an MSPB appeal, an OSC, and go to arbitration. I have to select one, And once I select down that road, I have to stay on that road. I'm not allowed to jump over to another road, or hopefully maybe one will do. So that's what makes it very complicated.
Got it. And Art, you mentioned something that I heard Bob say too about adverse actions, but employment actions as well. Can you talk a little bit about, explain a little bit about an employment action? And I think it's probably a good time too for both of you to jump in on prohibited personnel practices and
Sure.
the things that underpin these systems.
Sure. Personnel actions are what we're talking about mostly with the substantial rights that people are concerned about are the adverse actions that I referred to earlier. But employment actions can include anything from a detail, telework. There's obviously telework is in the news about the revocation of telework and agreements. Those are employment actions that are not adverse actions, and they may have different forms of redress. Sometimes it's only an internal grievance process. It may be a union grievance process. It may be no formal appealable process at all, unless, as Bob was mentioning, if there's a discrimination aspect of the employment action, you can have rights to the EEOC, but that would not grant you rights to say the Merit Systems Protection Board. We can talk about prohibited personnel practices. These are statutory. There's quite a lot of them. I believe it's 14. Anyway, I could be confusing that with other long lists. And by and large, prohibited personnel practices are not necessarily inherently actionable, but if you are aware that they're going on, you can go to the Office of Special Counsel and report that a prohibited personnel practice is ongoing or about to happen. And whether or not the Office of Special Counsel takes that up is going to be within their jurisdiction and authority. And there's a long list of what they will and will not take. And there's also, very important to recognize, is there's a long list of who you are that matters where you go. Because the Office of Special Counsel, for example, there's a number of categories of employment, like in the intelligence community or the FBI or certain other, it's all listed when you go to their website, that you can't go there. And so those are prescribed in other ways. So it's really important for employees to know what category they're in terms of where they're employed. We can talk a little bit about probationary and what those rights are for certain kinds of appeals. Such as to the Merit Systems Protection Board, having to do with your status as an employee. These are all really complicated and interrelated.
Yeah, and it's a good point, because as we've said earlier on, going and seeking legal advice, going and seeking HR, because it's so complicated, you really want to reach out to those folks. But you mentioned this is probably a good time to stop and say something. And I see Jackson, I'm going to finish my point, Jackson. That you might, answer a question, but also remind people that to figure out if you don't know your status, are you accepted service, are you probationary, are you, competitive service, any number of different types, that's located on your SF-50 form. So people can look in their personnel files and find out what status they have in the government. And Jackson, there must be a question.
Yeah, Jenny, I've got a few questions. And first, just want to start with the housekeeping item, because I think a few folks may have come in after you said it, which is that this webinar is being recorded and will be available online for those who want to share it or come refer back to it. And that recording will also include a transcript if folks want to be able to read the words of what's being said during tonight's events. So I want to move back just a little bit, and thank you so much for the explainers so far. I heard, Bobby, you mentioned the Civil Service Reform Act is one of the underpinnings for some of these rights. Could you all maybe talk through just sort of the difference between rights that come from statute, rights that might come from CBAs, and other places where rights can come from, and how they're different? I think some folks in the chat are interested in learning a little bit about that and the origins of these rights.
Okay. Yeah, so for the most part, the rights come from Chapter 75, 5 U.S.C. Chapter 75 of the United States Code. That covers employees if they're defined by 5 U.S.C. 7511. So there's Chapter 75, and you only can remove a federal employee if you're covered by Chapter 75 for cause that would promote the efficiency of the service. So generally speaking, Chapter 75 covers, not all the time, but misconduct type cases. So if, for example, an employee misused a government vehicle, the agency would propose their suspension maybe for 30 days, and they get an opportunity to respond. All those procedures are in Chapter 75. There's also what's called Chapter 43. Those are performance-based actions. And that's a little bit more complicated. Some agencies don't like to use Chapter 43, but Congress did set up a statutory scheme for poor performers that was designed to try to remove them efficiently, but Chapter 43 is really not efficient. There's lower burdens of proof for the agency. There's no mitigation of penalty in the Chapter 43 cases. And then as far as like other statutory things that go on is if you're a member of the bargaining unit or a union, there's the Federal Service Labor Management Relations Statute has a procedure in there. It says every collective bargaining agreement will have a way to resolve grievances, including arbitration. So in that procedure, if you're a member of the bargaining unit, the union can take your case to arbitration. That's heard before a private arbitrator that may or may not have federal experience. So that's generally the statutory scheme that's set up, as well as, I mean, then we kind of made reference to EEOC and OSC, but those kind of are the statutory scheme that's set up.
I want to just jump in real quickly and jump off something that Bob just said. So Chapter 43 is often considered inefficient, but I'll tell you what, as a longtime management attorney and someone in HR, Chapter 43 is also designed to improve performance. And that's why it's inefficient for removing people, because it requires a performance improvement plan. It requires the opportunity to improve. When you're under Chapter 75, it's the efficiency of the service. And while it can be a performance-based action, you don't have to do the other procedural steps. So Bob's absolutely right about efficiency, but it all depends on what your end goal is. So that's something I like to throw in there. But we can also talk briefly, and this is really complicated. Within Chapter 75 is the statute 7511 that talks about who's got appeal rights. And we all talk about probationary employees, and there's a lot of confusion, understandably, about what a probationary or a trial employee is, because it has different meanings to different people depending on how long you've been in the job you're in. And so we can talk about it really briefly, but it's exceedingly complex, and we don't expect anyone to remember it. But 7511 of Title V is the place to look to see where do you fall. And an important qualification too is there may be your status as a probationary employee is really about, Bob says this really clearly, about your status as an employee under this statute. Are you an employee in the meaning of the statute or not? And you can actually have passed the test to be an employee with those appeal rights, but you could be at an agency that has a policy to keep you or to put you in a trial period or a probationary period for a different reason. For example, you've been in the agency for a long time and then you get a supervisory job. You might be in a trial period for that supervisory job, but you may have appeal rights already as an employee under Chapter 75. So these are really important things to also, we can't pin it down for you here, obviously, but important things to know if you're facing this kind of situation.
Yeah, that's helpful, because I know probationary period has come up a lot. There was some OPM guidance that talked about agencies providing lists of probationary period employees. So even that, as you all are explaining it, might be tough just to have a list of probationary period because it's so complex. It's, and the other thing we hadn't talked about, but that occurs to me too, is that like when I was in government a couple different times, I was under different term appointments. And so again, depending on if you're Schedule AR or under some other authority, you're not going to have the same appeal rights necessarily as, say, a tenured employee. Is that accurate?
Correct. That's accurate. And yeah, correct. Because like it's very, as Art was referring to, it's very complex. As a matter of fact, when I was an agency attorney, when a probationary termination came across my desk and I had to do a legal sufficiency of it, it would take me about a half a day. I'd have to go through the OPF. I have to see, do they have prior federal service that they can tack on to their probationary period? Do they have 1 year current continuous service? Can they use prior federal service to meet that 1 year of continuous service? Are they veterans preference eligible? So, for example, attorneys are all attorneys are hired under the accepted service. However, and they have 2 years of a trial period, for example. But if you're preference eligible, veterans preference eligible, you only need 1 year. So you have to go through that whole analysis. And so I do have concerns that agencies only had 4 days to compile this list of employees. There's going to be mistakes, and each year I would estimate there's 20 reversals at the MSPB because the agency has messed that up because it's so complex of a analysis that they usually screw it up.
Yeah, and I think that's for so many of these things, they're moving quickly. And so again, that's why so many questions are out there, because it's not clear and easy. It's not as simple as just, looking at employees and categorizing them all the same way. One of the other places that we've heard people talk about, and I'm not sure if you all want to cover this or have thoughts on it, is folks on administrative leave, and whether, you won't put probationary employees, I suppose you could, on admin leave. And are there rights that kick in with admin leave? We've also been hearing a lot about RIFs. What's the general appeals process for those? Because I'm assuming they're all considered employment actions or personnel actions.
Well, administrative leave is not an adverse employment action, as kind of Art was referring to, because administrative leave, let's define it. You're in a paid non-duty status. So you're still getting paid, you haven't lost pay. And the only time you get, generally speaking, the only time you get to MSPB is when you lose pay. So administrative leave is a paid non-duty status. So you're generally speaking, you're sitting at home in that status, but you haven't really been harmed enough for you to go to MSPB. Now, it does could qualify as a personnel action under the whistleblowing laws. It's a change in duty assignments that could get you to EEO. You can say I was discriminated against and they put me on administrative leave for that, but you can't get to MSPB on administrative leave. Agencies were abusing administrative leave in the sense of, if an employee was under misconduct allegations and investigation, an agency would place an employee on administrative leave, and they would be on administrative leave for years. And so Congress stepped in back in 2016-17 and passed the Administrative Leave Act of 2016. And it limits administrative leave to 10 days. However, right before, at the end of the Biden administration, OPM finally came out with regulations. Those 10 days that limit of 10 days only applies to when an agency places you on 10 days pending an agency investigation into misconduct. After the 10 days is up, then the employee is transferred to what's called investigative leave, and they're under investigative leave for a limited period of time before the agency must report that to Congress. And then after that, they're on notice leave. So, for example, there's a lot of chatter about the deferred resignation program, that it's illegal because it violates the Administrative Leave Act limit of 10 days. But it really doesn't, because the 10-day limit is only applying to situations where the agency is placing you on that status pending misconduct investigations, and it follows that route.
Right. There's a lot of flexibility for other reasons to put
Right.
employees on administrative leave.
Right.
We've also heard a little bit about employees are talking about RIFs, and they're hearing about that in the news. I guess for removal processes as a personnel action, are there different appeal processes with those actions, with RIFs or with removals, typically under general rules? Or does it depend by the agency too? I know one of the things we haven't talked about is that, you mentioned Chapter 43 and Chapter 75, but agencies also have some layers of different policies under there too.
That's also, everything is complex, so that one is too. RIFs are generally appealable, and certainly if you're losing your job as a result of RIF, that's a removal. One thing to say about RIF is, and it's been a long time since people have seen them in any great size or scope, but so I don't know if people already realize this or not, but RIF is a very it's It's a funny tool. RIF is intended to be used for workforce planning and management and structural changes to the agency. And it contemplates that agencies will look to see, where do we want to refocus our resources? Where do we want to change programs? What do we want to emphasize as opposed to de-emphasize? And then positions are managed as a result of that and eliminated. Let me just say this as quickly as I can, given the limitations of time. There are many, many, many administrative steps that agencies have to take as they structure and run a RIF. So before a RIF is actually executed. And it starts with the performance, with the position description, which I think many people will recognize across government are woefully out of date. So the first thing that has to happen in a well-run RIF is the position descriptions need to be updated to reflect what people are doing and where they're doing it and the like. There are administrative steps about identifying what the scope of the RIF is, and then where people fit in the RIF. And it's usually run grade by grade within a position within a position structure. The one thing that I'll say about RIF is very often the positions that are targeted for removal like when you look at a RIF and say, what do we want to change here? The people who are in those positions very often end up in other jobs. And it is people who are not in the positions that are being targeted that may end up on the street. And everybody's heard about bump rights and retreat rights, and it's way too complicated to talk about here, but it has to do with the rights of the individuals who are in the positions that are targeted to be restructured. And so as a result, the people may stay and the job goes away or the job changes. And then somewhere else down the road, this is all based on your tenure group and your years of experience and your performance ratings. And all of those things factor into who loses a job in a RIF. And so it's very complicated, but people ought to recognize that if my position is targeted for RIF, it doesn't mean, it might, but it might not mean that I'm going to lose my job, or I'm going to lose that job in that position, but I may not lose my job in the federal government or in the agency.
Yeah, just like everything else, it's complicated. And I realized before we kicked off, I forgot to, when I asked the question, let people know that a RIF is a reduction in force, is what the acronym
Yes,
is
sorry.
for.
Yeah, it's lingo.
No, I did the same thing. I'm so
yeah.
I can.
But one thing to keep in mind is that all of the steps that go into the RIF, there may be a way to an internal procedure, and there should be a way to make sure that it's done correctly and redress a mistake. But those steps are not appealable. There may be through an agency grievance procedure if it's allowed, or a union contract. But as a general matter, putting you in a competitive level, in a competitive area, and all of those interim steps that take place, those are not appealable.
Just the final
It's the action that is taken to either reassign you or remove you that may be actionable within the framework of that action. Yeah.
Perfect. And Jackson, I'm guessing you have a question related.
Yeah, thanks for all of this insight so far. So seeing some stuff in the chat, because we just talked about administrative leave and then went straight into RIF. Some folks are asking, is putting someone on administrative leave the first step in a RIF? And I think that would be a good thing to clarify that process and maybe tease apart how those two things may work together sometimes, but are not necessarily related. If either of you could talk about that.
Bob, I don't know if you have a take on that, but my take is they're different things. And as Bob said, administrative leave is a it's a pay status, non-work status designation. I do not believe, and I've never seen the two put together. So and it's been a long time since I've been directly involved in RIF, but I do not believe that that admin leave impacts your status under RIF.
That's correct. Yeah. I mean, until this deferred resignation program came out, I mean, before that, there has been like comptroller general decisions that said administrative leave should be used sparingly for very little bits of time, like 1 day, 2 days. It should never be used for extended periods of time. So, but agencies have a lot of discretion with administrative leave. So they put employees out on administrative leave, but generally speaking, you want the employees doing something. You don't want them sitting at home collecting a paycheck doing nothing. So you wouldn't put people on administrative leave. You'd kind of get your ducks in a row to conduct the RIF and then do the RIF, but the employees would stay in their status. I'm sure the taxpayer wouldn't be happy about people sitting at home waiting for the agency to get their act together to conduct a RIF.
And I think that's it's a good point that a lot of these actions, whether it's appeals, whether it's RIF, whether it's some of these other personnel, you mentioned performance improvement plans, things like that, they're not quick typically in the way they run. A lot of these actually take some time.
Right. And I guess just to step back too, hopefully people are understanding too, as far as, and I think, just to understand the process of not a RIF, but removing an employee from federal service for cause. So what would happen is there's a notice of proposed removal, and in the notice of proposed removal, you would have, the agency has to spell out why they're firing you, a reason. They have to meet what's called a nexus. There has to be a connection between the conduct and the efficiency of service, and they have to prove the penalty, that the penalty of removal is reasonable. And for that last element, a deciding official has to consider what's called the 12 Douglas factors. And so there's, your prior work record, how long you've been a federal employee, the nature and seriousness of the offense, potential for rehabilitation. So that whole process, so when they issue the notice of proposed removal, the employee, as part of Chapter 75, gets an opportunity to respond. And they can't remove you from federal service until 30 days. So you have to get 30 days advance notice unless you committed a crime for which a sentence of imprisonment may be imposed, and then it's a shortened notice period. But you'll get 30 days, you get a reasonable time to respond. You could request an extension. So you may hire a lawyer, you can respond to yourself. You're entitled to an oral and written reply, and then you're entitled to a decision with the specific reasons therefore. So a decision letter that says, I sustain these charges, there is a nexus between the conduct and efficiency of service, and the penalty is this, whether it's mitigated or stays the same. A deciding official cannot increase the penalty, so if I get a proposed 14-day suspension, a deciding official can't say, you know what, I really hate that Bob Erbe, I'm now going to fire him. They can't increase the penalty, they only can mitigate the penalty. And then after that, depending on what that is, the agency spells out your appeal rights, whether you can go to MSPB, OSC, EEO, and if you're a bargaining unit, whether you can go to arbitration. So that's how the process plays out in the whole adverse action process. So I want to make sure people understood that. Like what's going on now with people just being fired, that's not really what is supposed to happen. that process is supposed to play itself out.
Yeah, there's usually, like you said, there's usually notice periods and other things. This is part of where we started, which is the due process piece that's typically been understood of how things work. So, Art, did you have anything you wanted to jump in on?
No, Bob nailed it. The one thing we were kicking around when we were just talking before this session is due process is kind of a legal, a constitutional theory, but the process that is assigned to each action is the process you get. And as a general matter, as Bob outlined, the due process essentially in an adverse action is notice, advance notice, and the opportunity to respond. That's the due process. But when lawyers talk about due process, it's really, is this, did you get due process of law? And that is the prescribed process. And due process itself is kind of a lofty concept that's not necessarily specific.
Yeah, and there are, as you said, there are things that are laid out in statute, and then there are other procedures. And
if so let's just give an example, like a real world example. Let's talk about the process that's laid out for adverse action. You're supposed to get 30 days notice. Let's say you got 29 days notice because there was a calendar mishap. If there's no harm to you, you didn't lose due process. You've had process, it's probably going to be deemed sufficient. If they don't extend your opportunity to respond, you get 7 days and then you ask for an extension and they say no, that's not a due process violation. You've had process.
Yeah, that's a good point. And a lot of this is so complicated, which is why, and so individual about what your status is, what the issue is, that this is where, and I think one thing I've heard folks ask before is that when you go through these processes, agencies are not representing the employees, right? And so people do need to, in a lot of this, it's not like you're necessarily going to an agency attorney to represent you personally in these things.
You're definitely not going to an agency attorney to represent you personally. They can't, as a matter of their bar ethics, represent anyone but the agency.
Yeah. And so I think that's always a good clarification for folks, because if you haven't been through it, I don't think you realize sometimes just the different roles that people play throughout.
Yeah, there may be very nice attorneys in the, in your general counsel's office that will be willing to explain things to you, but they're not representing you. And they might be helpful, but they don't necessarily have to be. And the same with true with HR in general. I mean, HR divisions, HR sections of agencies, some of them have strong employee relations places, employee relations staff that's dedicated to helping employees understand what's going on. But that's, been generally taken up with union contracts. And that's why union counsel does what it does under collective bargaining agreements.
Since you mentioned collective bargaining agreements, that's actually, I think, a question folks have is, how does somebody know if they're in a bargaining unit? If they're in a bargaining unit, does the CBA, the collective bargaining agreement, cover them unless they're paying union dues? I think there's a lot of confusion around that. Bob, is that something you can jump in on?
Yeah, so on your SF50, there's block 37. That's your bargaining unit status. If there's quad 8, 4 8s on there, that means you're not in the bargaining unit. If there's anything else, any other number in there, that means you are in the bargaining unit. Because if you're in the bargaining unit, you are covered by the negotiated collective bargaining agreement. So all the rights that are in the agreement are your rights, even if you don't pay union dues. There's still rights that you are given to be a bargaining unit member. So you're a bargaining unit member, you have those rights spelled out in the CBA. And the union has a duty of fair representation. They are there are some exceptions, but generally speaking, they have to represent all bargaining unit members equally. Now, one of the exceptions, however, is if the employee has another recourse. So, for example, if you have a bargaining unit member who's not a dues paying member who gets removed from federal service, they can either go, the union could take that case to arbitration, but the employee can go to MSPB. But the union can decide, listen, this person doesn't pay bar dues, and they have another avenue of redress. We're not going to take that case to arbitration because they're not a bargaining, they're not a dues paying member, and they have another recourse. So in that circumstance, that employee can only go to MSPB because the union has decided they're not going to take their case to arbitration.
So again, individual circumstances on each of those for folks. So I know one other question that we talked about, and that's sort of we've got the bargaining unit piece there. The other thing we haven't really touched on a little bit is, you mentioned, we've talked about MSPB a lot, but we also mentioned briefly Office of Special Counsel and EEOC. Can you both talk a little bit about the types of, MSPB, we've got the actions, the adverse actions, things like that. What types of things would go to Office of Special Counsel or to the EEOC?
So,
go ahead, Art.
Go ahead. Well, I was going to jump in about Office of Special Counsel. I had a lot of experience with that, especially while I was at DOJ. So the Office of Special Counsel is the enforcement arm. It's an independent federal agency. Was supposed to be, and it sort of grew out of OPM and out of MSPB when those things used to be way combined in the early days of the civil service, earlier days of the civil service. What the Office of Special Counsel does is it will oversee the investigation of prohibited personnel practices, and it may correct prohibited personnel practices. So employees can report when they believe a prohibited personnel practice has occurred or is occurring, and the Office of Special Counsel will consult with them. But then what happens is they don't represent the employee. They may take up the employee's case, but then they'll talk to the agency, and they'll talk to the agency head, and they'll direct the agency head, which they have the authority to mandate. They'll direct the agency head to investigate. And then the agency head usually has that delegated somewhere within the department or agency of how that investigation will take place. And then depending on the outcome, and this can take a while, but depending on the outcome, and they can subpoena, and they can demand documents, and they have a lot of authority to do that. But they're basically looking for violations of prohibited personnel practices, and they may stop them. And then they may direct the agency to take corrective action. And that is very often, once the OSC has sunk its teeth into something, you can reasonably expect it's not going to stop until they have directed the agency to take corrective action. They also can give the employee an independent right to appeal to the Merit Systems Board if the agency goes ahead and takes the action. So they can't force the agency, but they can certainly lean on the agency, and they talk to the agency, and they also talk to Congress, and they also talk to the IG. So they have those avenues. They also police, so to speak, political activity, which we won't talk about here, but that's the Hatch Act. We're not in a Hatch Act season, so to speak, although there could still be Hatch Act violations. When people are concerned about political issues now, it's usually political affiliation, which could be the basis of discrimination, which could be a prohibited personnel practice. And so that can be investigated by or authorized the investigation by the Office of Special Counsel. Maybe, Bob, you want to take the EEOC piece?
Yeah, and just to add on what Art was saying,
Oh, sure.
OSC also has jurisdiction over USERA discrimination, so military status discrimination. So if I was discriminating against my military status because my supervisor didn't like that I took a 5-month deployment to Hawaii, and now they're discriminating against me, I can go to OSC for USERA discrimination. And what has really exploded that Art alluded to are these individual rights of action. OSC is a very small agency, and there's a lot of whistleblowers out there. So in my practice, if I have an individual comes to me who believes they're a whistleblower, they're being reprised against for whistleblower activity, you have to first go to OSC and exhaust. So you can't just jump to MSPB. You first go to OSC and you file a complaint. So like Art said, OSC will investigate, and then they'll close that case out and give you an individual right of action. Then you can go to MSPB, and MSPB is going to want to know, hey, did you disclose all this to OSC? So you have to exhaust, and then you have to prove that you made a protected disclosure, and there's a connection between your protected disclosure and the employment action. But then if you prove that, the burden shifts to the agency to show by clear and convincing evidence that they would have taken the same personnel action but for the protected disclosure. And that's a very high standard of proof. And there's been a lot of litigation, a lot of successful litigation on whistleblower retaliation, and a significant amount of damages because of that, because the agency fails to prove that burden. So you definitely want to kind of explore whistleblowing activity, because that could be a potential viable claim.
Yeah, and let me just add to that in addition to, this is where the OSC is, kind of all-encompassing. In addition to being the enforcer of whistleblower discrimination, whistleblower retaliation, you can also, as an employee, make a protected disclosure to the OSC, which is in and of itself a whistleblower disclosure. So if you as an employee contact the OSC and say, I believe a prohibited personnel practice has been taken or is being taken, that is a whistleblower disclosure in most cases. They will also keep an eye out for whether the agency is going to then retaliate against the person who made that call.
And I know that's going to be a big one. And I'm going to put our plug in, is that next week we actually do have a whole explainer series webinar on whistleblowing, just because that in and of itself is a whole another process and category. So Jackson, guessing there's a question.
Yeah, so I think we have time for one more question. And I just want to say to everyone who has asked questions in the chat, we've received over 300. So thank you for putting those in there. We obviously can't get to all of them tonight, but we are using the questions that you send in to inform the future webinars that we're putting out and the content that the partnership is putting on our website. So please continue asking them, put them in the chat. It is all anonymous, and we are using that to try to get you content and answers as we can. So last question, and Bob and Art, we can maybe do this rapid fire. We've obviously had a lot of acronyms today, and so I was wondering if we could go through and just explain MSPB, EEOC and OSC. Bob will give you MSPB and EEOC, and Art, I'll give you OSC. And then maybe knowing that there's a lot of questions we haven't answered, one or two places where individuals here could get information on the types of reasons to go to each of those offices. And then we'll turn it over to Jenny to close us out.
Okay. So the Merit Systems Protection Board, MSPB, is a independent body. We talked a little bit about some of their jurisdiction. They have jurisdiction over adverse actions, 15-day or more suspension, demotion, removal. They have jurisdiction over USERA. I don't have to go I don't have to go to OSC first for USERA. I can go right to the MSPB. And just so you understand the kind of they have jurisdiction over performance-based removals as well. But so you understand the concept, they have regional offices throughout the country, and there's administrative judges that will hear your case. For an adverse action, the employee is entitled to a right to a hearing. So an administrative judge will hear your case. Ever since COVID, and they're continuing on the practice, they're usually over Zoom. So the administrative judge will hear the case and render a decision, and then that decision could be appealed to a 3-member board in Washington, D.C. And then from that, it can go up to the federal circuit if the employee is not satisfied with the decision. So that's like kind of an overview of the MSPB. And then the other one was Office of Special Counsel.
EEOC.
Oh, EEOC. So EEOC has jurisdiction over Title VII of the Civil Rights Act. So if you believe you're discriminated against because of race, sex, national origin, disability, age, reprisal for engaging there, so you have to go to EEOC. An employee has 45 days to contact an EEO counselor to initiate the process. And if you're untimely, that could affect your rights. So they'll try to resolve it during informal counseling. And then if they can't resolve it, they'll issue a notice of final interview, and then you'll have 15 days to file a formal complaint of discrimination. And then after the formal complaint, there'll be an agency investigation, and then you'll get a report of investigation, and you have 30 days to decide, do you want to have a hearing in front of an EEOC administrative judge, or do you want to have the agency issue a final agency decision? And either one of those are appealable to the full EEOC, Office of Federal Operations in Washington, D.C. So that's the general process in kind of a nutshell.
Yeah, let me just add to that the distinction about where you start. The EEO process is run by your agency. And so it's the agency EEO office or EEO staff for your bureau or wherever your subdivision is that handles all of the front end, the informal discussion, the counseling, the all of that Bob just mentioned. The EEOC judge hearing is the last part of that. And that's after exhaustion and completion of the agency process. And then, of course, you can go to federal court if you don't, at the end of that process, at the end of the EEOC hearing process. But yeah, that's in your agency. And right now, I'll just say, at risk of tippy-toeing against very sensitive topics, the DEI order has caused a lot of confusion in agency EEO shops because a lot of DEI activity has been run out of, managed, or otherwise sponsored by agency EEO programs. It's different across the board. Some agencies have dedicated DEI offices. Many of them use the EEO office of the agency to do that. So to the extent that there's a sudden missing DEI employee, there should not be a missing EEO staff. Those are different. But some agencies are not handling this well, from what I'm hearing. So just informally, and so it's important to make sure your agency EEO office is still functioning and there for you.
Right. And I should just mention the intertwine between those two, though. So if I have an adverse action, I got removed from federal service, and I believe it's partly due to discrimination. If I go to the MSPB, I can also raise an affirmative defense of EEO discrimination, and the MSPB judge will adjudicate that as well. Now it gets complex with mixed case processing, but also I could go the EEOC route but it's going to be a very long process, and it's going to go before you get to the MSPB hearing. So that's why you want to talk to an attorney of what avenue you should go, because if you go EO route, it could be years before, a year or 2 years before you get a hearing. Where if you go to MSPB, it's kind of a rocket docket. It's really fast. Usually I
like
prefer
that term.
MSPB.
Yeah. With that said, this mixture there is when the result has been an adverse action that you can go to MSPB over that may have a discriminatory basis. EEO process covers a lot of things that are not appealable to the MSPB, period. I mean, for example, and this is just a wild example, but someone could have a telework. Right now, telework it's a bad example just because of what's going on uniformly, but someone could have their telework agreement canceled for a discriminatory reason. You can't go to the MSPB under that for any circumstances, but you could go to the EEOC. So that's the distinction, or a distinction to keep in mind about where is the right forum.
And it's complicated, right? I mean, that's what,
yes.
Every time we go through these, I take away.
This is why Bob makes such a good living, because it's complicated. Yeah.
That's
I'm
right.
just looking at his wall back there. That's all I know. Yeah.
So, and so I think that's the point for employees listening to this. One, know your status from your SF50. Two, go talk to people, ask questions, because you can find information on each of the websites of Office of Special Counsel, EEOC,
sure.
Merit Systems Protection Board. You can find that, but because it's complicated, going and talking to folks who are steeped in the workings of the systems is important. So seeking legal guidance. I know some folks probably have professional liability insurance, which often is a starting point to covering employees. So, or going and talking to your union rep if you're in a bargaining unit. So I know we're at time here, and I just wanted to give each of you a minute if there's anything in the last minute or two here that we haven't covered that you were hoping to touch on.
I think we've covered what we could.
covered a lot of it, and I'm sure there are more questions out there, but we'll stop there. And thank you both for sharing your experiences and your perspectives with us. That's incredibly helpful. And I know for folks trying to navigate this process, a lot of these are front and center for people who have not had to think about these processes before in this detail. So appreciate it. As I mentioned, this will be posted on our website. It's our public service, ourpublicservice.org. And we've got a webinar space on there, other FAQs and resources. So certainly go there, check it out. We'll be updating it, and with additional resources, we're kind of a clearinghouse curating different resources from other places that employees can rely on. And then we will have another webinar coming up on Monday that's about the whistleblower process and procedures, and another one Wednesday next week on federal retirement and benefits and how those play out for employees in all of these different circumstances. So putting that out there for folks listening this evening. And again, just want to thank you all for tuning in. Really also want to thank you for your service as a federal employee. Both of you, Bob and Art, thank you as well for your service and for continuing to support federal employees. So appreciate everybody. Keep the questions coming and have a good evening.